Hi, I'm Victoria Syvret, a partner in the family law team at Aaron & Partners, and today I'm answering 5 common questions about family mediation. So a mediation session itself is usually set up for around 90 minutes. That's the common agreed time that we will aim for. The beauty of mediation is that actually you can set your own timing. So if we've got more or less to talk about, depending on the issues and the topic, we can change the meeting time accordingly. Generally, people will have between 2 and 4 sessions to deal with all of their issues. The maximum would usually be around 5. Mediation is a good option for people if they've definitely decided that they don't want to reconcile their relationship. Sometimes people mistakenly believe that coming to mediation is a way to help reconcile the relationship, and actually that would be more something for counselling or therapy at that stage. If they are decided that they are ending their relationship, they might have tried to discuss and agree matters relating to their children or their finances and been unable to do so. At that stage, mediation is a great option. People might feel like the other alternative is to go to court, and the idea of mediation is to avoid that step, allow people to come together and have constructive discussions to reach a resolution themselves. First step in the process is for either party to contact the mediator. That might be themselves or it might be via their solicitor. The mediator will then arrange a mediation intake and assessment meeting, otherwise known as a MIAM, with each party. That's to allow the mediator to get some background information from both parties and then arrange for the joint mediation sessions to go ahead. Put in its simplest terms, no, mediation does not produce a legally binding agreement. The beauty of mediation is that it allows people to discuss options and consider different ideas that they might have without being bound to it legally. At the end of mediation, what we're hoping for is a set of outcomes that everybody's mutually agreed and can then be really easily converted into a legally binding agreement by their solicitor. One of the core principles of mediation is that it's a voluntary process. So in short, people should not have to go to mediation if they don't want to. Certainly there are lots of reasons why mediation might not be appropriate for people, and that should be picked up by the mediator when they do their intake meeting. Recently there has been a change in the law that says even when court proceedings have been issued, that the court has an obligation to keep checking whether mediation should have been a better option for the parties and sending them back to mediation if that's appropriate.